Hello there, lovely that you're watching this video. My name is Stefan Flipse from Wintertaling Advocaten at the Zuidas in Amsterdam. We are a law firm that specializes in company law, so we assist companies from startup size to big companies on every legal aspect of corporate law. Today we're going to give you a short introduction about the UBO register. First, my colleague Esra will give you an introduction, then my colleague Onno will provide you with some examples and further clarify the rules concerning the UBO. And then finally I will provide you with the practical implications of the new UBO rules. Then I will already give away the conclusion of this presentation, namely at first that this UBO regulation is something that causes a big administrative load for you that you might not want to deal with on your own. Secondly, when you can't comply with it or you don't comply with it, the consequences may be severe. And thirdly, when you need any assistance with these rules and with complying to them, we are here for you.
Hi everyone, this is our first live presentation about the UBO register. My name is Esra and I will do the first part. I will do the introduction. I'm working as an attorney at Wintertaling in Amsterdam. So let's begin. So the UBO register will have a big impact on many Dutch companies and other legal entities. On June 23, 2020, this year, the Dutch Senate approved the Act on the Registration of the Ultimate Beneficial Owners of Corporate Entities and Other Legal Entities. This is called the UBO register. It's based on a European directive. It's called the Fourth Anti-Money Laundering Directive. The Netherlands is obliged to implement and introduce the UBO register. The background of the UBO register is to prevent the use of the financial system of companies and legal entities for money laundering or terrorist financing. And with the UBO register, it will become clear who has the control or owns the company or other legal entity. The legislative proposal implements a European directive, as I mentioned, and that obligates every EU member state to have a UBO register. On December 10th, 2019, the Dutch House of Representatives has adopted the legislative proposal to implement a UBO register. June 23, 2020, the Senate of the Dutch Parliament adopted the legislative proposal, and then July 8th, last summer, the first part of the legislative proposal has entered into force. This means that legal entities and Dutch companies are now obliged to collect and retain the information about their UBO and keep it in their personal files. And then on September 27, 2020, the UBO register is live. This means that all this information that the company and the legal entities has retained and collect must be registered in the UBO register. I will explain how, which authority and all that kind of things later in this presentation. And so on March 27, 2022, that's the other deadline, because already existing legal entities on September 27, 2020 have 18 months to register the UBO. So that means that on March 27, 2022, all the information of the UBO, of all the UBOs, have to be registered within the UBO register. Now we all know how it started, and we had a slight introduction of the UBO register. The UBO register will be a public and central register. And in the Netherlands, the Dutch UBO register will be part of the Dutch Commercial Trade Register, also called the Chamber of Commerce. Kamer van Koophandel in Dutch. The goal of the UBO register is to combat financial and economic crimes such as tax evasion, fraud, financing of terrorism, corruption and money laundering. Then, who will qualify as a UBO? Or let's start first with who is a UBO. The UBO is a natural person who ultimately owns or controls the corporate or other legal entity. And the control shall be determined by shares, voting rights, ownership interests, or other means. And later on in the presentation, in a different kind of video, then my colleague will explain more about who qualifies as a UBO. So it's important to note that UBO is a natural person, but there can be multiple UBOs in one corporate entity or in other legal entities. The UBO qualification criteria applicable are all different for the legal entities. So it will differ, and he will explain with examples and things like that. Then there's also the case when there's no individual that can be identified as a UBO or an ultimated beneficial owner, or there is doubt whether someone is a UBO. And in that case, the individual who holds the position of statutory board member, managing director, he will be the pseudo-UBO, and this will be registered in the UBO register as well, but it will be mentioned that it's not a UBO but a pseudo-UBO. In the next slide, we're gonna check who is subject to registration of a UBO in the UBO register. The following entities that are incorporated and established under Dutch law are required to submit UBO information to the register. It's the private limited company, also called the BV, and the public limited companies, the NV, other than those listed on a regulated market or 100% subsidiaries of such entities. It are also the foundations, stichtingen, associations, verenigingen with full legal capacity or with limited legal capacity, but with an operating business. Mutual insurance associations, onderlinge waarborgmaatschappijen, and corporations, coöperatie. Furthermore, all partnerships, maatschappijen, vennootschap onder firma, de VOF, and European public companies, SEs, European economic interest groupings, and European cooperative companies. Shipping companies, rederijen, and churches and spiritual organizations, kerkgenootschappen. So those are all subject to registration of a UBO in the UBO register. There are also a few legal entities that are not required to register subject to registration in the UBO under Dutch law. These legal entities are listed companies that are subject to certain disclosure requirements, and they're 100% direct or indirect subsidiaries, sole proprietorships, eenmanszaken, and legal entities covered by public law. Associations of owners, some historical legal entities, UBOs of foreign companies are not included in the UBO register, in the Dutch UBO register. And this also applies to legal entities with their head office or secondary establishment in the Netherlands. These entities will have to comply with the regulation in the country in which they are organized or incorporated. So those are not subject to registration of a UBO in the Dutch UBO register. So now we know which companies or legal entities are subject to registration of an UBO, who will qualify as a UBO, and that a UBO is a natural person. And then the question, who are obliged to register the UBO information? This means who from the companies or other legal entities are obliged to register this information with the UBO register. This is first the management board or partners of the legal entities. These are required to submit UBO information and are obliged to ensure that this information in the UBO register is adequate, accurate, and up to date. They also will have to reply if there are any changes in the UBOs. But also the UBO itself is obliged to comply and provide all relevant information which is necessary for the entities, for the legal entities, so the management board of the legal entities, to meet the obligations I said before, following from the UBO regulations. This is called, in Dutch, de meewerkplicht. Finally, the competent authorities and qualifying institutions. In Dutch it's called the WWFT-instellingen, such as banks, lawyers, civil notaries, accountants, and tax advisors, are also obligated from September 27, 2020 to report to the Chamber of Commerce any mismatch between the UBO information in the register and the information they have about the UBO from their own research, because they have to do their own research. This is called, in Dutch, the terugmeldplicht. These are the persons, entities that are obliged to register the UBO's information. So now we know which entities are subject to registration, who will qualify as a UBO, or an introduction. A UBO is a natural person and qualification depends on which legal entity. And we know who is obliged to register the UBO and the UBO's information in the UBO register. But which information will be registered and which of that information will be publicly accessible and which will be not publicly accessible? The information that will be publicly accessible of the UBO in the UBO register will be the first name and the surname, the month and year of birth of the UBO, the nationality of the UBO, the country of residence of the UBO, and the nature and extent of the beneficial interest held by the UBO. Then there's also some information that has to be registered but will not be publicly accessible. This is the citizen number, service number of the UBO, or the foreign tax identification number, the date, place and country of birth, the address, a copy of a passport or ID, and documentation supporting the conclusion that the individual qualifies as a UBO, and the nature and size of the beneficial interest from the UBO. This documentation will be the articles of association, a shareholders register, deed of incorporation, such kind of documents, for a BV and NV at least. The UBO information in the UBO register will remain accessible for a period of 10 years after deregistration of the company or legal entity. However, in order to respect the privacy of the natural person of the UBOs in the UBO register, there are a few extra rules. So, first of all, everyone who will look into the UBO register has to be identified and registered before they will get access to the UBO register. Second of all, the UBO register is only searchable on the name of the legal entity and not on the name of the natural person, the UBO. And finally, there also will be a fee charged for every extract from the UBO register you will get. But please note that there are a few authorities that will always have access to this data, such as the police, the prosecutor office, tax and custom administration, and the financial intelligence unit. There are a few exceptional cases when the UBO may request to the Chamber of Commerce to shield the public data. There are just a few. That is only possible when the UBO is a minor, on a security list, or there are guardianship or administration issues with the UBO. So in all other cases, the public data of the UBO will be accessible for everyone who will pay a fee, who will register and identify themselves. Thank you very much for watching this part of the video of the introduction of the UBO, where we just explained the main definitions of the UBO and how it will work. And in the next video, my colleague will explain more about how to qualify a UBO with some examples from the basis UBO to the more difficult ones. So please watch his video as well. And if you have any questions, please send them to the email address here under and we will reply as soon as possible.
Welcome to the second part of this presentation. My name is Onno and I will explain to you which criteria are applicable to different legal entities to determine the UBO. Let's start with the non-listed private companies, de besloten vennootschappen, and the non-listed public companies, de naamloze vennootschappen. Each natural person who holds directly or indirectly more than 25% of the shares or more than 25% of the voting rights is to be considered as a UBO. Also, every natural person who has an ownership interest of more than 25%, which means he's entitled to the distribution of profits or reserves of the company, is a UBO. At least each person who ultimately owns or controls a legal entity by other means is a UBO. Let me explain you the definition of other means by an example. If a shareholder holds 10% of the total issued share capital in a company, he qualifies not as a UBO. But if this shareholder is also a managing director of the company, and in his capacity as managing director he is entitled to appoint or dismiss the majority of the managing director, he is, by other means, considered to be a UBO. Let me give you 3 examples to visualize the foregoing. The first example, the simple basis. Mr. John holds 100% in BVI, so he is the UBO of BVI. BVI holds 100% of the shares in BVX. Mr. John holds indirectly, through BVI, 100% of the shares in BVX, so Mr. John is also the UBO of BVX. The second example is the indirect shareholdership. We have two BVs, BVK and BVP. The shareholders of BVK are Mr. Brick, who holds 20% of the shares, and Mrs. James, she holds 80% of the shares. Mrs. James is a UBO of BVK. Mrs. James is also a UBO of BVM. The percentage of 80% should be multiplied with the percentage of 50%, which means an interest of 40% in BVM. The UBOs of BVP are Mrs. Blue and Mr. Red. Mrs. Blue holds 60% of the shares and Mr. Red holds 40% of the shares. We have to multiply these percentages again with the interest of 50% in BVM. This means that Mrs. Blue, if we multiply 60 with 50%, is a UBO of BVM. She has an interest of 30%. And Mr. Red qualifies not as a UBO. If we multiply 40% with 50%, he has an interest of 20%, which is less than 25%. The third example, the pledge. In this case, Mr. Watson has an interest of 30% in BVM, so he will qualify as a UBO. Mrs. Baker holds 100% in BVN, so she is the UBO of BVN. If BVN as pledgee is entitled to the voting rights of Mr. Watson in BVM, Mrs. Baker is also to be considered as a UBO. Let's continue with two other legal entities. The foundation, de stichting, and the association, de vereniging. Each natural person who holds more than 25%, directly or indirectly, of the ownership of the company is a UBO. Also, if a natural person can exercise directly or indirectly more than 25% of the votes when deciding on amendments on the Articles of Association is a UBO, and at least every natural person who can exercise control over the legal person is a UBO. Let's continue with the administration office, de Stichting Administratiekantoor. The administration office is also a foundation with a specific purpose. If a natural person holds a sufficient interest, which means more than 25%, in a corporate entity through certificates issued by a Dutch foundation, this individual will still qualify as a UBO of the company. However, the individual does not qualify automatically as UBO of the stock. Pursuant to the administration conditions, the stock is obliged to pass on payments received from the company to the holders of the certificates. These holders of the certificates are not entitled to the assets of the administration office and therefore does not qualify as a UBO of the administration office. With regard to the limited partnership and the general partnership, every natural person who holds directly or indirectly more than 25% of the ownership in the company is a UBO. Also, who actually controls the limited partnership or the general partnership is a UBO. At least each natural person who can directly or indirectly exercise more than 25% of the votes in the event of acts of the management or amendment of the agreement is a UBO. My colleague Esra told you already something about the exemption for listed companies. Let me give you an example. Company A is a listed company and has 3 subsidiaries. She holds 100% in subsidiary B and subsidiary C, and therefore subsidiary B and C are exempted from its obligation to register a UBO. Company A holds only 50% of the shares in subsidiary D, and therefore subsidiary D is not exempted of its obligation to register its UBO. Let me give you an example with regard to the pseudo-UBO. If no natural person meets the criteria to determine the UBO, you have to register a pseudo-UBO. This can be the case if the percentage of more than 25% is not achieved, or if there's any doubt to which natural person qualifies as UBO, and all resources have been used to trace the UBO, but it has not been found. In those cases, the members of the management board of the legal entity should be registered as a pseudo-UBO in the UBO register. This was my part of the presentation. Thank you for listening. If you have any questions, do not hesitate to contact me. In the next video, my colleague will talk about the practical implications of the UBO register.
Hello again. Once again, I'm Stefan Flipse and I work for Wintertaling, and in this video I'm going to share a little bit with you about the practical implications of the UBO register. To start with, when should a UBO be registered? Like literally, which date should we take into account. The UBO register has entered into force the 27th of September 2020, and already existing entities have 18 months from that date to register their UBO, which means that the hard deadline to register your UBO is the 27th of March 2022. If you incorporate an entity after the date on which the UBO register has entered into force, then you should immediately register your UBO. So the point is, when you incorporate a new entity after the date on which the UBO register has entered into force, then entities will not get a Dutch Chamber of Commerce number unless or until they have registered their UBO. Another addition to this rule is that when you have an existing entity, you have 18 months to register your UBO. However, if the UBO changes within these 18 months, the UBO should be registered immediately. So from the moment that the change appears. Secondly, I'm going to share with you the obligations that the UBO has himself, because the UBO has an active collaboration obligation, which means that he actively has to contribute to the register being in place properly. If he fails to do so, the punishments that are possible are quite serious, namely an imprisonment of 6 months to up to 2 years, or a fine of over 21,000 euros. So we should all, or as a UBO, you should really pay attention to what you're dealing with and what you should be actively doing. Thirdly, there are not only obligations for the UBOs themselves, but also for the management board, insofar as where it's not the same person. So the situation could exist that the UBO is also in the management board, then it's practically the same. But this example also points out the obligations of the management board when they are not the UBO. So generally, the management board has to submit the UBO information. They can do so quite easily by checking the website of the Chamber of Commerce, on which there is a form that you can just fill in and upload. In this form you have to upload certain documents, which are in the PowerPoint, but I'll just read them out, which is a copy of the passport of the UBO, a utility bill, the Articles of Association, the shareholders register of the company, a register of depository, an organization chart, finally the deed of incorporation. Another practical implication of these new rules is that the Chamber of Commerce will actively pursue UBOs to register their information in different phases. Additionally, the UBO rules also create obligations for competent authorities and what we call in Dutch the WWFT-instelling. These obligations are twofold. Firstly, they are required to check the UBO register, and secondly, they have to obtain an extract of the UBO information and keep it in their personal files. However, having an extract does not release the WWFT-instelling from its original obligation to perform its own research to the client. And also, when they do so and they find out that the UBO register is not correct, then they have the obligation to communicate that to the Chamber of Commerce. Next, I will zoom in a little bit on the feedback obligation, which is the obligation of competent authorities, such as the WWFT-instelling, to report any discrepancy between the UBO register and the research they have to conduct and they have conducted on their own, back to the Chamber of Commerce. First of all, when we keep in mind that already existing entities have 18 months to register their UBO, there are no discrepancies yet. So the first 18 months you're sort of safe, which means that there's also no feedback obligation. However, if there is a discrepancy, it should still be reported. So if an entity manages to register its UBO within those 18 months and then according to the research that the competent authority has conducted, the UBO register is not correct, then still there should be communication with the Chamber of Commerce. They should let the Chamber of Commerce know that the register is incorrect. A means to actually report this deviation will be launched intentionally 2 months after the implementation of the registration duty for the UBO, but it remains unclear what exactly it will look like. However, by then we will surely be able to give you an update on how to proceed. Well then, this is the end of our presentation. I really hope you enjoyed watching it, but nevertheless, if you still have any questions, please do not hesitate to contact me or one of my team members, Marijn, Tim, Tom, Esra or Onno, and we will get back to you as soon as possible. Thank you for watching.